Part 3, Sections 9 and 10. A GAL may work with a large variety of clients over time. Understanding issues that impact these clients will make the job of the GAL easier. In this section, we will examine how immigration issues might impact a client and how biases can impact a case. In the course of your practice, you may represent an immigrant child. Understanding the requirements for a youth to apply for special immigrant juvenile status to obtain green card residence in the United States will be necessary. This allows for appropriate referrals to be made and assistance granted for the child. Special immigrant juvenile status, referred to as SIJS, provides an avenue for youth to obtain legal permanent residence status in the United States. SIJS provides a green card to allow youth to remain in the U.S. permanently and gives eligibility for employment authorization, student financial assistance, and places the youth on a path to citizenship. If U.S. citizenship and immigration services are denied, it is possible that the youth may be referred for deportation, so it is recommended you seek assistance of an immigration attorney before this application is made. As the GAL, you are responsible for recognizing when this may be an option and then referring the client to an immigration attorney. You are not responsible for filing these immigration applications, and doing so without the proper knowledge and training could harm your client. The process of obtaining SIJS uses a hybrid system of state and federal collaboration. Federal law places critical fact on functioning in the youth's best interest and having jurisdiction under state law to make judicial determinations about custody of care of juveniles. In order to file for SIJS in the U.S., the juvenile court must make 3 determinations. The first is that the child has been declared dependent on a juvenile court, or that the child has been placed in custody within the United States. Second, the child's reunification with one or both parents is not viable due to abuse, neglect, or abandonment. And third, it would not be in the child's best interest to be returned to his country of nationality. The juvenile court does not make an immigration decision based on these findings. Preliminary determinations are prerequisites to filing an application for immigration relief from the U.S. Citizenship and Immigration Services. With these findings, an application for admission to the status of legal permanent resident status can be filed with Immigration Services. The Violence Against Women Act, VAWA, provides domestic violence protective orders and allows certain non-citizens to file for immigration relief when they have been battered or subject to extreme mental cruelty by a parent or spouse who is a U.S. citizen. A successful VAWA applicant first receives notice of approval of her prima facie case, then approval of the VAWA petition. Receipt of both approvals permits a status adjustment to become lawful permanent residents. Immigration relief under VAWA can offer qualified recipient services such as waivers, which would allow benefits, derivative status to stabilize immigration status and maintain family integrity, and protective orders. VAWA relief may also allow school, medical, counseling, and welfare records to remain confidential and prohibit further dissemination of released records. As with special immigrant juvenile status, careful screening by an immigration attorney is warranted. As the GAL, you are responsible for recognizing when this may be an option and then referring the client to an immigration attorney. You are not responsible for filing these immigration applications, as doing so without the proper knowledge and training can harm your client. You may be introduced to victims who are in the U.S. as a result of a human trafficking offense. UNT visas were authorized to Congress to address issues that arise from these offenses. U visas were authorized by Congress in 2000 as part of the Victims of Trafficking and Violence Protection Act, the TVPA. U visas are available under one of the 2 conditions. The first is for non-citizens who have suffered substantial physical or mental abuse as a result of a qualifying criminal activity that occurred in the U.S. or violated U.S. law. The second is that a person possesses information concerning substantial physical or mental abuse as a result of a qualifying criminal activity that occurred in the U.S. U visas are granted when that individual has been helpful or is being helpful or is likely to be helpful in the investigation or the prosecution. The U visa provides authorization to remain in the U.S. with employment authorization for up to 4 years. However, the recipient may qualify to adjust status to a lawful permanent resident after completing 3 years on the U visa status. The U visa is a generous immigration law and may permit extension of U visa status to qualifying family members. As the GAL, you are responsible for recognizing when this may be an option and then referring the client to an immigration attorney. You are not responsible for filing these immigration applications, as doing so without the proper knowledge and training can harm your client. Like the U visa, the T visa is authorized by Congress through the TVPA. The T visa is distinguished by the fact it is available to a person who is in the U.S. as a victim of a severe form of human trafficking and meets all cooperation criteria with law enforcement. Commercial sex trafficking of children is considered to be a severe form of trafficking in persons under TVPA. A severe form of human trafficking is defined as sex trafficking in which a commercial sex act is induced by force, fraud, or coercion, or if the person induced to perform such act has not attained 18 years of age. A third qualifying definition describes recruitment, harboring, transportation, provision, or otherwise obtaining a person for labor or services using force, fraud, or coercion with the purpose being involuntary servitude, peonage, debt bondage, or slavery. In most cases, persons who qualify for the U visa will likely also qualify for the T visa. As with the U visa, recipients of the T visa can qualify for some forms of public assistance and can provide waivers to bars of benefits that apply to persons who achieve permanent resident status through other immigration relief avenues. Again, it is highly recommended to consult with Immigration Counsel regarding each unique person and circumstance. As the GAL, you are responsible for recognizing when this may be an option and then referring the client to an immigration attorney. You are not responsible for filing these immigration applications, and as mentioned previously, doing so without the proper knowledge and training can harm your client. A resource in Colorado that you may use for resources and referrals is the Rocky Mountain Immigration Assistance Network. You can find further information on their website. Understanding how immigration impacts a client is only the start of understanding the differences of each of the clients. A GAL must be aware of how bias, both their own bias and the bias of others, might impact their case. In this next topic, we will examine topics such as cultural sensitivity, the role of poverty, and supporting LGBTQ clients. While working toward a better future, youth need to feel connected with a family, culture, or community on their own terms. Youth who are removed from their birth families can lose touch with their culture of origin. Paying attention to the cultural context of a child increases the likelihood that the services provided will positively resolve cases and protect the child's safety and well-being. Good practice requires that when you are acting as a child's representative, you understand who the child is and what the child's background is. It is of utmost importance that you set aside your own background to discern what is important and in the best interests of the child. Research in social cognition regarding bias has gained substantial attention from social and cognitive psychologists. It is important to be aware of both explicit and implicit bias, understand the difference between the two, and develop a safe environment for the youth. Explicit bias is a conscious preference, either positive or negative, for a social category. Implicit bias is a positive or negative preference for a social category that operates outside of one's awareness. Components of bias include stereotypes, prejudice, and discrimination. The majority of child welfare cases across the United States involve people who live at or below the poverty line. Maltreatment, neglect, and child poverty have a substantial economic impact on the American legal system, state child welfare agencies, and other institutions. It is important to remember that child maltreatment is not confined to one or several racial, religious, or economic groups, but is defined by each person's unique circumstance. Your role must be to teach, provide support, and set expectations for moving forward. Lesbian, gay, bisexual, transgender, and questioning youth are in America's child welfare and juvenile justice systems in disproportionate numbers. One sexual orientation does not define him or her as a person, nor does it frame the needs the individual may have in the system. Like all young people in care, LGBTQ youth have the right to be safe and protected. You should not assume the child is heterosexual, and you should communicate acceptance, sensitivity, and respect about the child's sexual orientation and gender identity. There is no need to be shy regarding inquiry to the client's orientation, because it could play a significant role in her child welfare system experience. It is important to offer information to ensure LGBTQ youth receive the support and quality services they deserve. The Child Welfare League of America and Lambda Legal are additional resources. They offer a toolkit of information, including basic facts about being LGBTQ, information for youth in care, family support, caseworkers, foster parents, attorneys, GALs, and advocates. Information also covers working with transgender youth and provides other LGBTQ youth resources. The Toolkit: Getting Down to Basics, Tools to Support LGBTQ Youth in Care is available on the lambdalegal.org website.